Let me ask you this, Ms. Kawaj. When you make these telephone calls and you know that they're going to the jail, you know that all these telephone calls are recorded.
Prosecutor saves the day regarding disputed recorded jail calls after Florida judge had to explain to one of the defense attorneys, yes, you heard that right, the judge had to explain the meaning of public jail phone calls to one of the defense attorneys, and the prosecutor saved the day. And I think this is information that everyone should know. Have I got you interested? What happened? Well, Circuit Court Judge Robert Wheeler explains to one of the defense attorneys in the Justice for Dan Markel trial in such a way that I had never thought of, and it's well worth listening to. But first, let's listen to a recap by the prosecutor Georgia Kappelman to remind us of the background regarding this case.
Members of the jury, the evidence has shown that on July 18th, 2014, this community suffered a blow when revered law professor, colleague, son, father, brother, and friend was gunned down in broad daylight in his own home. What enemy or enemies had Mr. Markel made that set into motion such a brutal act? The answer, his own family. What offense had Mr. Markel committed against these people? Wanting to be a good father, refusing to let his children be taken away from him. You've heard a lot about bits and pieces versus the full picture. This is the full picture, ladies and gentlemen of the jury, and this is what all the little bits and pieces over the last couple weeks have added up to. What was the motive for this murder? Wendi Adelson characterized her divorce as unpleasant, but the evidence shows that that is a severe understatement. When they separated in 2012, Wendi Adelson left with the children while Dr. Markel was away on a business trip. This is from State 75. Quote, the wife was gone, the boys were gone, the house was half plundered, the Schwab accounts had been raided, and divorce papers had been left on the bed. Most importantly, there was no indication of where the wife and children were. Worse, for the first 15 days of the separation, wife refused to give husband any address or phone number for where she lived with the children. On September 25, 2012, wife finally answered husband's and his counsel's plea for the proper address, but she gave him a false address that wasn't corrected until 4 weeks later. When Markel came home from a business trip and found divorce papers on the bed, they demanded the majority of time sharing with the kids, temporary and permanent child support, temporary, bridge the gap, lump sum, and durational alimony, and the wife's attorney's fees and costs. In Markel's response, he said that he is, quote, grieved that the wife has filed for dissolution of the party's marriage, and it is his hope, belief, and desire that the marriage can be saved. Well, we know it couldn't. In January of 2013, Wendi Adelson filed a motion to allow her and her children to relocate to South Florida. They were ages 2 and 3 years old at that time. As one basis for this request, Wendi Adelson cites that the wife's parents reside in Coral Springs and the wife's brother resides 20 minutes away. The children are very close to the wife's parents. Then she proposes a 60-40 time-sharing schedule in which Mr. Markel will be required to travel from Tallahassee to South Florida every time he wants to see his children. Quote, the wife proposes that during the school year, the husband come to South Florida every other Saturday through Tuesday, and in the off week, come for at least 2 days to see the children. As another basis for the motion for relocation, Wendi alleges that, quote, the husband has also created a hostile work environment for the wife at FSU School of Law by telling the administration and their joint colleagues that the wife has stolen from him, that she has mental health issues, isolating the wife in Tallahassee's small legal community, and further limiting the wife's career prospects in the area. Now remember what Wendi Adelson told you when she was on that stand. She was just fine to stay in Tallahassee. She liked it here in Tallahassee. In Markel's answer, he indicates that he's seeking continued equal time sharing in Tallahassee. He seeks sole parental responsibility on issues related to education, religion, and the medical upbringing of these children. And as y'all learned through the course of this evidence, you learned how important it was for Mr. Markel to be involved in the kids' education and their religious upbringing. Markel's dedication in these areas is highlighted by the fact that the very last thing he did after he dropped his kids off and worked out was make a phone call to Stuart Schlazer, somebody that he was reaching out to try to get information about the kids' schooling prospect for the kids. In addition, you'll recall Wendi Adelson's testimony that Mr. Markel was devout in his beliefs and was adamant that his boys should be raised in an environment that observed Jewish traditions and was committed to the Jewish faith.
There is an update to the Dan Markel case, and on the screen you can see all the people that are involved, and most of them have already been sentenced to prison, and we'll talk about this in a bit. But the former brother-in-law of Dan Markel, Charlie Adelson, has already been found guilty and is serving a life sentence in prison. Donna Adelson, Charlie's mother and ex-mother-in-law to Dan Markel and grandmother of Dan Markel's 2 children, is also charged and is awaiting her trial. Check out my other videos on this case. You can find them in the True Crime playlist, though I may have to dedicate a playlist to the Adelsons, as this case has captured the world's attention because of the unthinkable criminal behavior over child access. So let's watch a clip of what the judge had to explain. Then I will give my views. I have sped up the clip, and if you want to know how to slow it down, I will leave a link to my short video that explains how to slow down a video that I've sped up.
Then what the testimony would be, I would thereby be entitled to that, which I'm not allowed to stop.
Let me ask you this, Ms. Kawaj. When you make these telephone calls,
Yes, sir.
and you know that they're going to the jail, you know that all these telephone calls are recorded.
Yes, sir.
All right. And that they're going to be reviewed by somebody, listened to by somebody, regardless of whether it's the state or somebody else, somebody associated with the state, law enforcement, okay, not the prosecutor's office, but the state. I mean, with law enforcement or somebody working at the jail or somebody is going to review this telephone call.
And Your Honor, that is why timely discovery is normally, if that did put on notice that the state was going to be putting these jail calls, that would be different. But also, too, Judge, if the court is going to find that because the calls were recorded, my portions of the conversation should not be understood. If they want to take a listen to Mr. Garcia's portions of the conversation, that's fine. But any discussion that I have made with him is entirely my opinion and work product in preparation for the defense with my witness.
You know all of these are recorded and somebody's going to listen to them.
Well,
Don't you? Isn't that a waiver of your work product? I mean, you can't go into, talk in a crowded room and not expect your work product to be heard by somebody. Isn't this the same thing? Even more so, where you get a recording at the beginning that says these are going to be recorded. Somebody's going to be listening to this. Somebody's going to get it, and it's not now a confidential information or a confidential conversation between you and whomever at this time. Some third party has already listened to it. Isn't that a waiver of the work product?
When we got calls from me and Ms. Magbanua, the moment that they realized what it was, even though they were being recorded, they had to stop listening to it.
To Ms. Magbanua?
In previous hearings, Judge.
That's different. That's attorney-client privilege. That's not what this is. Work product privilege is very different from attorney-client privilege. I would agree with you with that. I mean, and that's why they say if this is attorney-client or they make some statement like that, don't say anything. You're on the wrong line. You need to call somebody else. You need to get another line and make that call in a different manner. That's what they tell you. And so, but that's what they tell you in the jails if you listen to the recording.
This call is subject to monitoring. It doesn't say you are being monitored or you're monitoring live. But I agree, I'm just letting you know because I can memorize the recording.
All right. You know that it was being recorded. You know that somebody's going to be listening to it at some time or another, or it has potential for that.
Yes.
Isn't that a waiver?
Not in my opinion, Judge. I would love to have some research on this. It's just that this is such a unique circumstance, Judge, just because of the nature of the fact that this person hasn't been.
Well, I agree with that.
And that he is a co-defendant up until the fact that his case was over. We didn't have access to him. So, I mean, I'm of the position now, Judge, that the only thing that they shouldn't be able to listen to is my portions of the conversation, because I can tell you I directly discussed defense strategy with Mr. Garcia. But
all right, so
listen to his portions, and yeah, I don't know how they're going to manage to do that. I would
that was my next question.
Subject for impeachment, Judge, if he were to take a stand and testify to something different. But as it stands right now, I mean, I agree with Ms. Kappelman, they're not admissible in their case in chief, but I do think it would be improper for them to listen to the calls as it relates to my portion discussing defense strategy.
All right. I don't think she said that they were inadmissible in her case. I think she said she was not going to use them in that manner. So that's different. All right. So you're saying that just your statements.
Just my statements, sir. Because I don't believe that if my statements are the only one that he would be considered defense strategy. Because I listen to something else. So my words are defense strategy.
All right.
Your Honor, if you want, I'll discuss something with Ms. Kappelman of some other things that I heard.
Wow, that's a lot to unpack. The person speaking to the judge is the defense attorney, Tara Kawas, who is the defense attorney for Katherine Magbanua, who was talking to the judge about calls she had made with Sigfredo Garcia on public jail phone call lines that were recorded, and the prosecution's office had received the recorded calls. And just to give you a little background of what was going on in the trial at this time, it was alleged that he, Sigfredo Garcia, was the shooter. Spoiler alert, he was found guilty. But it is what she told the judge that I found interesting, and I will discuss what she said because I know it was a bit hard to hear. So I'll discuss that in a bit. As this may be why Donna Adelson did not know her jail phone calls were being listened to. And I'm wondering if Donna Adelson did not watch this trial where the judge talks about the phone calls not being private, where there is no client-attorney privilege if the call is made on the public jail phone number. Okay, does that all make sense? So I thought everyone knew that jail phone calls were being recorded. However, I can understand what they're saying, but let me tell you from the jail phone calls that I had heard Donna Adelson when she was talking to her son, Charlie, about his trial. So we know she watched his trial. And what's interesting about that is that there is a recording of Donna Adelson telling Charlie to be careful on how he behaves in jail because they are monitoring everything. She even discusses on the prison call with Charlie that if she needs to tell him anything private, she will tell his solicitor, who will in turn tell him. Does that sound a bit dodgy? Why would she tell him that? Couldn't his attorney have told him that in private? Now you might be thinking, well, who cares? The judge explains something that everyone should be mindful of, and you might not have even caught it. So here, let me play it for you again, because the judge is very clear.
You know all of these are recorded and somebody's going to listen to them.
Well,
Don't you? Isn't that a waiver of your work product? I mean, you can't go into, talk in a crowded room and not expect your work product to be heard by somebody. Isn't this the same thing, even more so?
Now, I had never thought of jail calls that way before, that jailhouse calls or prison calls are no different from being overheard in a crowded room. Isn't that an amazing way to think about it? And what the defense attorney says to the judge, in my view, is intriguing. Now, it is hard to hear. That's why I want to tell you what she said. Even if you slow it down, it's a bit unclear. You have to really concentrate to hear what she had said. So she said she did not know the state was going to be listening to the calls. And she says, it says when you call, the call is subject to monitoring. It does not say you are being monitored or you're being monitored live. My curiosity is, why would an attorney need the judge to delve into the intriguing world of privacy rights when it comes to phone calls from behind bars? And why is she explaining to the judge that even if she's on a public line, this would come under client-attorney privilege when Sigfredo Garcia is not even her client? The judge is not so sure about what she's saying, and her discussions with him would fall under work product if they are on a public line. So what is going on? What is the difference? In my view, it is that client-attorney privilege only applies to communications between an attorney and their client. Maybe everybody doesn't know that. Though, I thought if someone else prepares material that will be used in litigation, then those documents that were prepared for the litigation, for the trial, then they are privileged and private, even if someone else prepares them. The problem is the judge is not accepting this, and now she's trying to tell the judge that she was discussing defense strategy. Then it should be covered under her work product. Now, we don't hear how the judge would have decided because the prosecutor, Georgia Kappelman, saved the day by saying she would not listen to those parts of the calls. Well, for years, law enforcement has been catching criminal activity by way of listening to recorded phone calls. The one that immediately comes to mind is the infamous South Carolina serial killer Donald Pee Wee Gaskins, convicted for 10 known victims, but he admitted to hundreds. Can you recognize this chap? He is DeCarpulian. He was one of the defense attorneys in the Murdoch case, and many decades earlier, he was one of the prosecutors for the serial killer Gaskins. So he switched sides. from being a prosecutor to being a defense attorney. I would love to ask him why. If you're interested in that case, I found a great YouTube video that has a documentary on Pee Wee Gaskins, and you will see Dick Harpootlian discussing the case, so check that out. Dick Harpootlian said Gaskins' common solution to ordinary problems was to kill people. So this is how he was caught. Back in the day, prisoners had to use payphones. Gaskins made his own recordings on tapes. The tapes were later found in his prison cell. Caught on these recordings plotting to kill another inmate with Tony Simo. Gaskins was hired by Tony Simo. His mother and stepfather owned a grocery store, and in 1978 a guy named Tyner robbed them for $200 and shot them. As a result, they both died. Tyner had not yet been executed, so Simo hired Gaskins, who was in prison, to kill this guy named Tyner. The first attempt to kill Tyner did not work. The second attempt did, but Gaskins denied he was responsible for the death. However, the recorded prison calls between him and Simo were damning evidence. So, prison calls can be used in trials and can be used against you if you are the defendant and if you are the caller. Yes, you heard me right. The caller could be committing an offense. And in the Gaskins story that I just told you about, Tony Simo was charged for hiring Gaskins. Law enforcement has a huge benefit to be able to monitor and record prison and jail calls, but there is a huge difference when it comes to jail and prison calls to inmates over here across the pond in England and Wales compared to America. Here in Britain, the public does not have access to jail or prison calls. What do you think about that? Should the public have access? Listening to prison phone calls can be very addictive, and in the Donna Adelson case, you will find there are many YouTubers broadcasting prison calls. I recommended one in my last video, so check that out. And when I was watching Duty Ron, he was recommending a YouTube creator who is dedicated to providing full prison and jail call recordings with the dates and timestamps on them. And when Duty Ron recommends somebody, well, I tend to trust his recommendations. Maybe I'm a little biased. So on the screen, you can see the channel that he's recommending. So check them out. I will also put a clickable link in the top of this video and see if you can catch any incriminating information. They have a great playlist regarding the Adelson case. Maybe you can find something that the prosecution will use in the upcoming case against Donna Adelson in her trial. I must note, as we've just been having an update on the Brian Kohlberger case, that the court can make an order to seal records. I don't know if anybody's ever seen any prison phone calls from Brian Kohlberger. So far, I'm not aware of any. So what do you think? Will they release them after the trial? Because I'm sure the prosecutors in his case have also been listening to the calls. What do you think? By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.